That's good. All right. Very something above the safety or the appraiser
and things like FHA. Well,
or anything discussed by our staff. Your mic today, I guess. Where's the mic?
You already have the second one so it's very, very active. That and other every type of national state.
Actually, the system worked the best yesterday. I've ever seen it work.
Really?
Once it came in wrong, but it didn't freeze. We had a three-way in the city. And I mean, the quality of pictures. I've never seen such a good building that's worked well.
This seems to be the easiest because only because we're webcasting, IT gives us a code that we have to dial into, so we're all in on the same conference call, but it's a dial-in number, so and it seems to work fine.
But isn't this a different system manufactured than the other ones we have?
I think so. I think it is.
They work better.
We're over a week period, weeks and months, and now, like every day, you're getting stronger.
Where are we going?
Yeah.
They really don't want your money.
We're staying.
Alrighty, thanks.
Yeah.
Busy. Yeah, I was out Friday. I was out a couple days before.
Wait.
It was quiet. I was in Montreal for a day. It was quiet out there.
I didn't get to. Locked myself in.
But the housing is pretty fairly strong out there. But the Fisher kids, you know what I mean? They're not going out on the boats. It's the day trippers that are doing
Look
it.
again in the morning. It's your limit. Yeah, did you get my snotty email this morning? No. I was on the phone, Mark, said, I'm giving you a warning. I said, I'll say catch you in a few minutes. No, you'll still be able to warn her before she gets it.
She's a tough business. And then competitions, everybody's so here.
Someone has to have it. Otherwise, we have a problem. We're doing tickets, we're not tracking.
Yeah, no, I answered your email. I have a pretty comprehensive one. They're all supposed to help.
They came back actually against the
Yeah.
So,
Just a little bit.
I don't think I can because yeah.
just a little bit.
Carol?
Yes.
Beverage related.
Yeah, can you move your
They
camera?
couldn't sell,
Our camera.
Yeah, just
Yeah.
a little bit, because it's just cutting off the head of half of the people.
But yeah, the idea was to have a pattern.
Yeah, that's fine.
some chips.
We're ready on this end.
How you doing? I thought they really asked. You didn't mention your name.
Yeah, Bob's finding this is like,
Oh, honestly, I have it.
The destruction.
Kids and everything. Really? How are they doing? Good. How do you like that model?
With zeros.
And what about your daughter? We're not
Gotta have at least a few eyes. Same stuff to get some.
Are we ready now, buddy?
you guys ready, right? Let's start. Forward that to ready. Yes, we are. I'll take a look. That's true. Yeah, that's true. I can't be true.
I'll wait for John to sit down.
Okay. We'll wait for John.
I have my own issues over here. I understand everybody's got a job. Yeah.
Good morning.
Renee.
Hope everyone is doing fine. Welcome. I believe this is our first meeting since we met last year, and it's been quite a few busy months for the Department of State staff with respect to some of the real estate issues. So I know that we have a few items in the agenda that need action today, but we're also going to discuss some important issues that are coming up through the Trends Committee. And this morning I was having a conversation with counsel for the department. This meeting is basically going to be unofficially known as the Whitney Show, since most of the items are on her portfolio today. So thank you very much. Let's go to our first item, and we'll roll call. David?
David Leno.
Trisha O'Connor Francis. Sandra Erickson.
Diane Ramirez.
Gregory Weston.
Eileen Spinola.
John O'Hara.
Joseph Burko. Akil Qureshi, Department of State.
Marcos Vigil, Department of State.
Duncan McKenzie.
Melanie Grossman, Department of State.
Mary Jo Moore, Department of State.
Carol Fansler, Department of State.
John Goldman, Department of State.
Mark Mastrobuno, Department of State.
Keith Simon, Department of State.
Whitney Clark, Department of State.
Kathy McCoy, Department of State.
I'm David Dworkin.
Who's around?
Ron Schwartz, Department of State.
Well, thank you very much. Let it state for the record that we have quorum and we'll be able to take action on the action items today. Has everyone had a chance to review the draft summary of the November 13 board meeting? Any comments, edits, or changes that anyone would like to state for the record? No comments? So can I get a motion to approve the draft summary?
Motion to approve.
Have a motion on the floor. Somebody second?
Second.
Second? All right. So anyone opposed to getting them approved? All right. So we have approval of the draft summary. Now we have an enforcement update. Department of State, we have John Goldman. John, are you ready?
Yes, sir. Good morning, everybody. I was not in attendance at the last board meeting, so I apologize if some of this information may be redundant, but I'll just give you the nuts and bolts of the statistics that were provided to me, just to give you a thumbnail sketch of our enforcement efforts.
John, hold on a moment. Carol, can you move up the camera a little bit because we can't get John on the screen? A little bit more. There we go.
I'm ready for my close-up.
My show.
That's right. Okay, during calendar year 2012, again, just to give you an overall thumbnail sketch, we docketed 953 complaints for the real estate discipline that came into our complaint review unit. If I'm interpreting these statistics correctly, of those 2012 cases, approximately 350 still remain open, which is not to mean they're in the they could be in the investigative stage, they could be pending disciplinary action. Nonetheless, they have not been disposed of. There's still some action ongoing or pending. For comparison purposes, on a quarterly basis, this quarter, January 1 to the end of March, we docketed 190 real estate cases. And just to clarify, that includes both consumer-initiated complaints, investigations that we initiated on our own through some information we received, source, etc. For comparison purposes, during the first quarter of 2012, in the same time period, we docketed 264, which, if I did my math correct, is a 28% reduction for first quarter 13 compared to first quarter 12. That's all I have. I just wanted to kind of give a basic. I have some other statistics here that they create some confusion because they're carryovers from previous calendar years in terms of cases that were initiated prior to 13 in terms of the disposition of those cases. And so I'm not going to go into those unless you have specific questions.
Anyone has any particular questions or concerns about the report?
I wasn't clear. 953 complaints. This is first quarter? Is that?
The 953 number represents 12, calendar year 2012.
This is for 12. Okay.
The full calendar, the full last calendar year.
What stands out to you as particular areas of the highest complaints came in what particular areas?
In my experience, it always revolves around some form of agency or another. Fiduciary duty, consumer comes to us, feels that their agent failed to represent their interests in some way, shape, or form. I categorize it as agency. I've been doing this for 23 years, and that has always remained a constant.
I have a question, may not be the time to ask, but I'll ask it anyway. When you are a firm that has a complaint against you, we are never notified that the complaint was resolved. The understanding is the complainant is told it's been reviewed and nothing further is happening. But we never have an opportunity to close it from our standpoint. Is this true, and is there any way, if so, is there any way of changing that so we know that it's been resolved?
I would agree with you. We've been somewhat inconsistent on that policy. There was a point in time when we would copy the respondent and perhaps their principal brokers of record when we send a closeout letter to the complainant. Perhaps that's something we should revisit. When the case is forwarded on to legal, if charges are pursued, obviously they're informed of that through that avenue.
Right.
I'm unsure as, pardon me?
That's what I understand, but it's when it is resolved that we never get any notice that it has been.
Right, and I think that's a fair point, and
Right.
to the extent that has been inconsistent with respect to each investigator's type of practice, we're going to fix that, and we'll definitely set it up so that it's definitely fair that each
Right.
agency gets to know exactly what happened to the case, regardless of whether it's going to counsel's office for further investigation or prosecution,
That
or
would be
that
helpful.
the matter is resolved.
We take it serious, and we want to know if it was resolved.
Yeah.
Thank you. I would appreciate it.
Mr. Vihil, I would just comment that we communicate with the respondent more so on an informal basis, because unfortunately the levels of supervision, very often the field-based investigator forwards the results of his or her investigation to some degree of supervision, and so in other words, there's an informal level of communication that I suppose we certainly could improve upon. But I would say that's the no communication whatsoever to the licensee in terms of where a case is going is certainly the exception to the norm. It's I would say overall it's informal, but I would agree. I think once a determination is made when we communicate with the complainant, the consumer, we could just as easily copy the licensee as to where the file is moving, if it's moving at all.
Right, and I'm aware that many investigators do that, but to the extent that it's inconsistent, they'll definitely fix that problem.
Thank you. Very much appreciate it.
All right, any more questions for John? All right. Next item, I think that this is where we begin the Whitney show.
Actually, I'm turning over the first part to my friend Duncan McKenzie.
All right, good morning. The Trends Committee had a conference call on January 10th, and we dealt with two issues. One of them was based on the letter that we received from the Attorney General's office regarding confusion in the marketplace about the allowability of rebates. We discussed the matter and some of the suggestions from the Attorney General's office. and we agreed that the department should go forward and attempt to seek legislation that would clarify the statute about the allowability of rebates when they are not involved with a licensable activity. NISAR has offered to help the department get some legislation introduced, and we're working on that now. We don't have a draft yet, nothing to share, but that is moving forward. The second item that we had dealt with the amount of time that between receiving the deposit check and when it must be escrowed. It was very unclear in the statute before. There's a proposal that you've seen before, and that was included in the original emailing that you received with the agenda, and that will be an action item, so I won't go over that now. There are some other issues before the Trends Committee, and this is where I pass it back over to Whitney.
Thank you, Duncan. I'd just like to add on the rebate issue, because legislation does take some time. What I'm going to be doing is preparing a frequently asked question and short article or blurb for our website, so we can get something out sooner to the industry to start to provide some clarification on the issue of permissibility of rebates.
I'll add to that, Whitney, that we're doing a big outreach on that as well. We did something in our magazine, and we'll continue to really circulate what's acceptable in the letter that you did back in 2008.
Thank you. Another issue that the Trends Committee discussed was the creation of an inactive status for licensees. I believe this was brought to our attention by Tricia O'Connor-Francis. It is a legislative change. So what I've been doing, I've been researching laws from other states, and there are a fair number of states that do have an inactive status. I've pulled some legislation that I think New York could use as good models. They do differ. The largest thing that we still need to discuss and agree upon is how we're going to treat continuing education. Some states allow somebody to come back from an inactive status with no CE for the inactive periods. Other states require varying course hours from full CE compliance to a fewer number of hours. So we are going to be referring this back to the Trends Committee for further discussions, and hopefully we'll have draft language for you at the upcoming meeting. Another issue that hasn't yet been discussed by the Trends Committee, but was brought to our attention by the Long Island Board of Realtors, is a trend by certain municipalities to create local laws or informal policies that appear to require brokers to overstep the bounds of their permitted scope of practice, to delve into areas such as unauthorized practice of law, perhaps unlicensed home inspection, and other things that would also be a violation of our current statute and regulations, such as possible agency violations. So I know the Long Island Board has been trying to resolve these issues on an informal basis. I'm going to have it met with complete success. So we're going to refer this issue back to the Trends Committee for discussion. And what we're probably going to do is draft a letter to the Office of the Attorney General's office asking for a legal opinion on the permissibility of some of these local laws. And in those discussions, I would like to invite Kathy Nolan and Doreen Spagnolo, who have been very active in this, to assist us in the discussions. And I'll also be reaching out to our contacts in the home inspection industry, because we do regulate that profession as well, for their opinions on some of these local laws.
Whitney, while you're referring that to the Trends Committee, what is the status then of the agent's adherence to the local law?
The adherence to the local law, that's tough. I mean, some of the laws that I've seen, there's one in Nassau County in particular, in my opinion, would force a broker to violate their agency requirements under our statute. So I think they're really the catch-22 right now. Certainly they're required to comply with local laws, but at the same time they're required to comply with the state statute. So I think it puts them in agents in a very difficult position. Unfortunately, we don't have any guidance as a department right now because it is so settled. So we are hoping to move this along so that we can get some clarification to provide these licensees with the necessary guidance. And that's all I have for the Trends Committee.
Anyone else has any questions for Whitney on these topics? I do want to acknowledge that with respect to both the broker rebate issues and to the Long Island Board situation, we have representatives of their offices here, and they will be available for the public comment periods. But I just want to acknowledge Emily Granrun and Matt Siegel, both from the Office of the Attorney General, Eric Schneiderman, and thank them for being here and bringing this issue to our attention. Also want to acknowledge the presence of Liz English and Moses Serum from the Long Island Board. Thank you very much for joining us today. If there are no questions with respect to these issues right now, then we're going to move to our next item on the agenda, and that will be an issue for the Education Committee.
Okay, Sandra Erickson, I'll report on that. There were 2 items for the Education Committee. One was to review and make suggested changes or updates to the broker curriculum. This is a work in progress. The committee met last week with the help of Mark Mastrobuono, and we will continue to review the current curriculum and meet again on May 7th to discuss and propose any changes to the broker curriculum. The second item was to discuss and make recommendations to the board regarding CE for agency and diversity. The committee spoke at length about agency at our last meeting, as well as possible agency required CE. Proposed changes will be discussed at our next meeting. As for cultural diversity language for CE, the committee will wait for final approval of the regulations before any further discussion on the topic. This should take place in about 2 months. I want to also mention that the committee reviewed the responses of the surveys that Mark created that was sent out to real estate schools. High on the list were to expand the hours of office operations, that was number 1, as well as agency and real estate investments. And certainly want to thank those schools that took time to respond. It was very helpful. And that ends my report.
Thank you. Anyone have any questions? All right, so now we move to the action items. The first item is the issue of deposit of funds.
You've all been previously given a copy of the proposed language, and I'd like to make a motion for its approval.
Anyone second the motion?
I'll second the motion.
John
O'Hara.
All right. Any opposed? All right. So, all in favor, say aye.
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 Opposed? No one? Motion is approved. Second item, we have the advertising regulations. Whitney, do you have any comments?
I do. If it's acceptable, I'll lead the discussion on this. I have gone through all the public comments received. I forwarded copies to the board members. And I'm also in receipt of some proposed language from NYSAR that I've also forwarded to the board members to guide our discussions. In addition, before today's meeting, I had a phone conference with Anthony Gatto from NYSAR and Neil Garfinkel from REBNY to go over the proposed changes. I think the 3 of us are in agreement on the revisions that we think are appropriate. So I'll discuss those with the board, and then I'll turn it over to you to see if there are any other issues that you would like to discuss relevant to the public comments received. In your folders, you have a copy of the language as proposed. The first is in subdivision B2. This is regarding authorization to place advertisements. We received one comment from a commercial broker in the city who raised issues surrounding the common practice amongst commercial brokers. And he explained that a lot of the listing agreements require broker cooperation, and in fact, the way a lot of commercial brokers advertise, the consent to share listing information is implied. His concern was that requiring written permission of the listing broker would slow down the process and make it unduly burdensome for commercial brokers to do business. So what is proposed currently is in the second subdivision. Right now it requires written permission to advertise another broker's listing. Proposed to the term written, so that just permission is required. This would allow some flexibility. It would allow for implied permission. And certainly brokers could still require written permission. In my opinion, it would be the safe practice, because then you would have proof that you obtained a broker's permission before advertising their listing. But it would also provide flexibility for some commercial and other brokers who wish to offer implied or more informal permission. Any discussion or opposition to that?
I mean, as a practical matter, isn't it smarter to make it a requirement for written authorization as opposed to just going on an honor system? I mean, doesn't that just seem like a better practice for this particular item?
Practically, yes. I think it would be the safer way to practice. I think it would be to the benefit of both brokers to have the permission codified in writing. But I realize there are some brokers who feel written permission is cumbersome and would like to offer more informal permission, verbal, implied.
Question. How formal does a written permission have to be? Could it be email, as opposed to a letter?
Yes, I think
if it's
any
electronic,
kind of written.
if it's electronic, I don't really see how that's possibly burdensome. I mean, it'll take you a minute, 30 seconds to codify that in writing.
All right, no, yeah, I agree. I mean, it doesn't require a formal letter or contract. I think any kind of writing, including email, would suffice.
Could we just review again, because I don't think everybody has it in front of them. You're saying that the language will still say you need permission.
Correct.
So if something goes awry in the relationship, the proof of the person that is advertising the exclusive, they would have to prove that they had permission. Am I understanding that correctly?
You are, Eileen.
Okay, thank you.
I think that's a great point. I mean, at this point, it really is to the benefit of only one of the parties necessarily to do this. If they want to do it, then they can, but it's not required. And again, it's a very common practice in the commercial field not to have these written agreements. And as far as I know, and the enforcement department can tell me, I don't think there's a lot of controversy, a lot of actions taken between brokers with regard to failure to properly identify or get the okay to go ahead and advertise a listing.
Well, simply because I would say that the vast majority of listings are in writing, so consequently it's, the listing itself serves as the authorization by the property owner to market the property. I mean, in the case of a verbal listing, I can't think of any instance in the past where a seller or a landlord said, I never communicated the authority for this broker to market my property. I would agree with you 100%. It's a non-issue really.
John, what about the scenario where there's an exclusive listing and another broker is advertising the property? Has enforcement seen In your experience, many complaints on that issue?
You mean outside the scenario where both brokers are the members of the same MLS?
Correct.
Again, I can't think of. I mean, this day and age, the vast majority of practitioners belong to boards and multiple listing services. And so I've seen it in the vacation for short-term rental scenarios, the Finger Lakes, the Hamptons. With verbal leases is the only kind of thing that comes to mind, where a property owner will authorize multiple brokers, but then it becomes, and it's verbal, and becomes an open listing. It's it's not exclusive, so it's up for anybody who the seller is willing to authorize to market the property. No, I would say I don't. In my experience, I don't see it as an ongoing problem issue.
I think you mentioned something that is, it's not unique to our state, but we are in the minority. New York State recognizes verbal exclusives. So, as long as we say you have to have the permission and the burden of proof is on the person advertising that they have the permission, I don't see an issue. But the fact that we still acknowledge verbal exclusives in this state, I don't know how we can then say it has to be written.
Sure.
Do we have a consensus on this change?
If the board is okay, I'm going to open it up for one particular comment for someone that has worked on this issue,
Yeah.
if you would.
This is Neil Garfinkel. I worked with Whitney on this issue. I think you just made an interesting point that many residential brokers cooperate within MLS environment, RLS. Most commercial brokers do not cooperate within that context, and that's why this is an important point. There is more of an informal relationship and understanding amongst commercial brokers. So while we're still requiring that permission, it doesn't give rise to the level of written permission. And that was something that I just wanted to comment on. Thank you.
Thank you, Neil.
Okay, do we have consensus on this change? Yes?
Yes.
Yep.
Okay. All right, moving forward, the next proposed change is to subdivision C1. This is contents of advertisements, the name of the real estate broker. This comment came to us from a licensee who correctly noted that our current regulation provides, we have an and in the first sentence. It says advertisement shall indicate that the advertiser is a real estate broker and provide the name of the broker or real estate brokerage. Our current regulation uses the word or. And this, this would add additional expense if we were to make this change, because it would require, especially in print advertisement, at least another name. So it was proposed to make this provision consistent with the current regulation, to replace the word and with or.
Seems reasonable.
Anyone have any concerns or comments?
No.
Okay. The next proposed change is in subdivision D1. And this pertains to classified advertisements. The concern was that as the language is currently drafted, it will result in increased expense for licensees due to the per line cost of classified advertisements. So NYSAR has proposed some new language to address that. It would require that the classified ad name provide that the advertiser is a broker, or provide the name of the brokerage or brokerage. So we'd be omitting the address and phone number requirement. Is there any concern with that proposed change?
No.
Okay, moving forward, the next proposed revision is to subdivision D3. This pertains to web-based advertising. We received a lot of public comment on this provision. The overwhelming theme of the comments seemed to be that as drafted, the language would require extensive and expensive redesign of agent websites. NYSAR has given us some proposed language on this. It would remove the requirement that every page of an agent website link to the brokerage website, and rather require that the link just be on the first page, and clarify that every page would have to have the remaining information that's required under the rules and regulations, but it would change the linkage requirement.
Whitney, just for purposes of clarification, what we're talking about is that the linkage will only be required to be on the home page then, correct?
On the home page, correct. As drafted, it required it on every page of the website.
Any concerns with the change?
No.
No.
Okay. Moving forward, the next proposed change was to for sale signs. Again, this was another area that we received a fair number of public comments. The theme of these comments seemed to be geared towards expense. That as drafted, the regulation would require that a large number of signs become redesigned, and that would result in great expense to licensees. And also that many for sale signs are geared towards a specific agent. So NYSAR has proposed some language on this. It would remove the requirement that the broker's phone number be on for sale signs, but still require that the name of the broker or brokerage be present. Is everybody okay with the proposed language?
Yes.
Yes.
It's fine.
Yep.
It's fine.
Moving forward, this is to the next section, advertisements referencing property not listed with the broker. After the language was proposed, Neil Garfinkel from Redmead correctly noted that there was an unintentional typographical error. In this provision, there's the phrase absent consent provided. We had that in the wrong subdivision. So the way that it read, it would allow for a misleading or false advertisement if the advertising broker had the listing broker's consent, rather than having that phrase be in subdivision 2, which would allow a broker to refer to property listed with another broker if they had the consent. So NYSAR has given us language that would correct that. I believe as drafted, it does meet our original intent in proposing this provision. Is there any objection to the proposed language?
No.
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 Okay, the next proposed change is in the next section, teams, under team name.
Where is that?
You have that?
No.
I don't think we have that.
We don't have
Team
that.
name.
No.
Okay, this is a very small change, let me explain it to you. The way that the regulation was proposed, it said that team names may use the term team. What we had discussed in subcommittee and in board discussions, and I believe intended, was that the team names must use the term team. That you couldn't use other phrases.
Right.
So the proposed change is to change the word may to must.
Right.
That sounds
fine.
That's reasonable.
Okay.
Yes.
Right? Everyone
That
okay?
sounds fine.
Yes.
Okay.
Okay, and yesterday, I heard from Duncan. The way that the rule was proposed, we had indicated that it would become effective 90 days after publication of the notice of adoption. So that, given publication schedules to the state register and time to finalize the paperwork, that would make this rule effective sometime in August or September. Duncan mentioned that it may be easier for implementation if we pick a solid date that's easier for licensees to remember, such as January 1st. If you'd like to make that change, I can. I just need to correct the paperwork.
Is there
Should
any?
we ever make anything? Should we ever make anything effective on a holiday?
Well,
I know. In all
January
honesty.
1st was a convenient date, I suppose, but the issue is that, let's say it was going to be effective August 17th. It's kind of a,
Yeah.
it's not an easy thing. It's not a bright line that's easy to find. So January 1st, or you can make it the 2nd if you'd like, but this would just make it easier for licensees to kind of have that determinate date when they need to really be compliant by.
But why not October 1? Is there a why so much further? Why not October 1? That's
It could
definitive.
be October 1. I was trying to think of a date where we could give people enough time, give us enough time to go out and reach out to the industry, let them know what's going to be required of them. And from my standpoint, I suppose the more the better. But if the group prefers October 1st, that's not a huge issue.
If you think you need the time, that's.
I think it's 6 months is a time to get it out to the industry, and I think that would be a good idea to give it the 6 months, my opinion. Good change.
Okay, that sounds.
So what, saying October 1st?
No,
Or saying
saying
January 1st?
January 2nd.
January 2nd? Okay. January 2nd it is. All right. Were there any other public comments that any of you would like to discuss? No. I think we're ready for a motion.
I move we adopt the regulations as proposed and amended.
Second.
We have a motion.
Second.
Any discussion on the motion? All in favor?
Aye.
Aye.
Opposed?
Hallelujah.
Wow.
Yeah.
Right?
All right. No opposition? The motion has passed. All right, I will go ahead and file the necessary paperwork and make the rule effective January 2nd. Thank you all for your hard work. Also a special thank you to Anthony Gatto from NYSAR and Neil Garfinkel from Redney. You've been a great help in this long process, and we really appreciate it.
Thank you, Whitney, and we also want to recognize your own work putting this together. It's not been an easy task, and we know that you received multiple comments, and putting together the language that was of approval by everyone in this community. I know it wasn't an easy task, so we appreciate the hard work as well. The next item, new business. Any particular issues that the board would like to bring to forward?
Mr. Mihail, I just wanted to, I have a little bit of a concern about the escrow regulation. As I'm sure everybody knows, the industry practices differently in different geographical regions. Outside the 5 boroughs and Long Island, the local boards generate for their membership the offer contract forms that their members use that establish a contract of sale between the buyer and the seller. And in my experience, they all include provisions as to the handling of the deposit, and they vary. Some of them say as promptly as practical, and some of them specifically dictate, they'll say within 72 hours of the acceptance by the buyer, and they're kind of all over the place. So I guess just from my perspective, is there going to be an effort to communicate with the local boards, because they're going to have to do a mass change of their offer contract forms. Okay.
Absolutely, and where we are procedurally is we're at the very beginning of the rulemaking process, and so I need to draft the necessary paperwork, and we need to get approval from the governor's office and the regulatory review unit.
So
and
that's
that
down
could
the
take
road.
some time.
I see. Okay. Thank you.
Any other new business? All right, so now we'll move to the public comment period, and for purposes of members of the public that haven't attended or are not familiar with the procedures of the board, this is your opportunity to bring in particular issues over to the board for their knowledge or discussion. Doesn't mean necessarily that the board will engage in a discussion right now with you about the subject or debate it, but definitely to bring it to their knowledge, and then obviously the members of the board can bring it to the discussion. As well, if there's any of the items that were brought to fore that you have something of concern or a particular position that you would like to leave for the record of this meeting, this is our opportunity to bring it to the fore. So now we open it up to the floor. We'll start here in New York City, then go to Albany, then go to Buffalo, to the extent that there's any public members there. Please identify yourself for the record, and I will welcome for you to, when you're speaking, to at least come over to the table, just because it will be easier for the recording and for everyone else to see who's bringing the subject. So, any public comments? Yes.
My name is Kathy Nolan, and I'm from the Long Island Board of Realtors. And hi, Whitney. How are you?
Kathy?
We appreciate the fact that you did put that business about what's happening on Long Island in particular, but New York City as well, and worse, I think, in the city, as far as the regulations by the municipalities is concerned. We also have a problem that I haven't mentioned to you yet, but is coming with some of the villages, in that they're fining brokers when they take a listing and a homeowner's house is missing COs. So that's another issue that I think we're going to be tackling sometime in the future. But right now, Whitney sent a letter to us quite a while ago, and I think you might have a copy. Whitney, there's a copy in all the kits? I don't know.
Yes, it's in everybody's folder, Kathy.
Okay, and it was a letter in response to what I had sent her, dealing with what Nassau County regulated in terms of source of income protection. Is it yes or no?
Yes, it's
okay.
Right next to the agenda.
The issue in Nassau County is that source of income is a protected class now. And so this regulation, or this white paper that they put out, actually came from Suffolk County. And so when it came to Nassau County, we had to deal with it, and we never had to deal with it in Suffolk County because source of income is not protected in Suffolk County. So it doesn't matter what somebody says. If it doesn't apply, they can say whatever they want. But the minute source of income became protected in Nassau, we looked at it, and you'll see there was one that was all marked up, and that was their first regulation, or their first paperwork. And what we did with that was we addressed it with them at the Department of Social Services in Nassau County. And I have to tell you that then they gave us a second version of it, and we're in talks now to try to rework what their regulation is. But they've said now, the big issue was, as you pointed out, Whitney, agency, and the fact that Nassau County was saying you have to be an agent of the tenant if you're going to get paid by the Department of Social Services. And we had discussed the fact that if it's your listing and you now are required to take somebody on social services, you can't represent that person unless you give up that listing, and it puts you in a terrible position. So that was only one of the issues. Then there was the matter of whether or not you had to do
you had to practice law without a license, and then the inspections they required, which meant you had to have, as Whitney stated, you'd have to be a home inspector, and if you acted as a home inspector, you're doing it without a license, and that's untrustworthy. So she really gave us a wonderful outline for how we should deal with this in Nassau County, and we gave that to the Department of Social Services, and they were very receptive to it. So we're going to have ongoing talks with them about that. But the city of New York is more of a problem, and I guess Neil's going to be much more involved with that one, because the city of New York requires that, number one, you sign a paper stating that everything you've said is true, and if it's not true, it's a Class A misdemeanor. So that's a problem for the brokers. Then also they said you're only allowed to collect 1/2 month's rent as your fee if you're getting paid by the Department of Social Services. But you can't refuse the agents, the people who come in from the Department of Social Services. So you're being forced to work for a wage you might not agree to, and you don't have any way out of it. And then, of course, they want you to look for the violations, and they want you to do all the other things like practicing law without a license and all the rest of it. So this is really very onerous, but there's one other thing that they've added to it that's like the elephant in the corner on top of all the herd you've got in the middle of the room, and that's that they say if the broker is the owner or someone affiliated with the broker is the owner of the property, no commission can be collected. So let's suppose I'm a broker and I have an apartment building and I put those listings through my office and one of my agents rents one out. Well, of course, we're all affiliated, nobody gets paid. So that's a real problem. It's just really nutsy. So we've got to deal with the Department of Social Services and the Human Rights Commissioner in the City of New York. And on top of everything else, they've got that other regulation now where you have to have the sign up in your office, and the sign has to be up if the majority of what you do involves having to get credit information, et cetera, mainly in rentals. And yet we've had, Barbara Ford, right, Whitney? Mm-hmm. Barbara Ford has taken a case where she's argued, I thought she argued beautifully, but she was unsuccessful, so she's going to have to appeal it, that it wasn't the majority of this man's work. Mostly what he does is sales. Very little of what he does is rentals, but he's still got the fine. So they're coming at the real estate, the real estate profession from every direction. I get it. I know that they're all broke, these municipalities, and this is a nice way to earn a few dollars and pick on the brokers. Everybody hates them anyway. But the fact is, we're really, just as we think it's safe to go back in the water, there's somebody else coming at us. So all I hear is the music from Jaws as I'm trying to work all this stuff out. So Neil's been great. I sent him some of the stuff, and I know we're going to work together on that. And I also gave some information to some other attorneys who couldn't believe what was going on, and they said, to keep them informed as to what's going on. But this is a serious problem in the downstate area, and it affects the way people make a living. And it's just something that, I think indentured servitude has been off the books now. We're not allowed to do that anymore, except if you're the government, I guess. But anyway, so I hope that the government will help us undo this mess, all right? And those are my comments, and I'm sure Neil has something to say as well. But thank you.
Okay. Can I make I just want to make a comment that it's always been illegal for anyone who owns or manages a property to collect a broker's fee. It's not allowed. So I just want to note that.
We're not talking about a broker not being able to collect a fee. We're talking about any agent in his office.
No, but
being
no,
able to
the
collect
broker.
a fee.
You can't collect a fee on an apartment or a house that you own for rent. You cannot collect a broker's fee.
But if you have an agent?
No.
Oh, all right. Well, I think we should address that then, because I think the license allows you to collect a fee.
Not if you own or manage, so that's against the law.
Well, I think we should look at that too then. That's my issue.
Well.
And I will state, just for purpose of clarification also, as to with respect to the HRA policies right now, as we discussed in the prior meeting, there are some very egregious cases that the department is investigating and acting upon with respect to the disclosure of the 50% fee. We're taking a serious look. The examples that we have already discussed show that there was legitimacy to the concern of the department. So there may be other issues that we definitely can discuss, and I think that it's an opportunity to bring in HRA to discuss with the department and to any other parties concerned. But with respect to that particular closure to the pending investigations, I can't go into a little bit more detail, of course, because they're pending investigations, but that's something that counsel's office is aware of.
One more thing I forgot to mention. They, if you take somebody who's on any social service, they're no longer giving a security deposit, they're only giving a voucher. And when you see, the problem is when the landlord can't say no because of any of these things, he doesn't have to take a voucher, but they're saying, well, that's what we're giving, so now you're kind of stuck. It's a mess. It's a real mess, and it's a mess for any landlord in the city of New York. Certainly, you're in real trouble. And Nassau County, luckily, we're dealing with them, and they seem to be responsive. But I don't think the city is as responsive.
Thank you.
Thank you.
Any other comments?
May I?
Yes.
Hi, my name is Silvana. I took a little break. I just put in my Brooks application because I like to be an instructor. I love to teach and find mistakes. I'll probably be bashed for this, but I took Albany, Newburgh instructor course, and there were plenty of people there from Long Island, and no disrespect, the New York law is for all, but for some reason Long Island has, like what you spoke, it should be fair game for everybody. A voucher is what the landlord will take if they accept it. That's a source of income. If they have an apartment, it's rented. But you'll deal with that. I think they need to be more updated, all the agents from Long Island, on the clarity of fair housing, ethics, and all. But my question is, today is Administration Day, right? So if you look on the calendar, I think the big problem in the real estate offices are the brokers with their paid employees on what they do and what they should not do in regards to a license law. And that is a big focus. I think everybody's misguided on that, because if the broker tells their paid employee, an agent, an admin, on how to fill out a form that should not be filled out, and then all the agents see that, and they do it too, everyone's breaking sort of the law on filling out a listing, I think there should be more instructions or more guidelines given to admins, because sometimes here you're in Manhattan, but when you're in Staten Island, Long Island, the Bronx, Brooklyn, and you have a mom going for work part-time, make a couple of dollars, because the majority of admins will be working part-time because brokers don't want to pay full-time and they don't want to pay benefits, is the fact that they're doing above their means and they have no idea because they need a salary and they're doing jobs where they should not be doing. I don't want to go into full detail to the fact is that there should be a guideline on the admins on what they're doing with the brokers. Because sometimes I feel the broker's telling me I have to do this. And you're saying, if someone's new, like for instance me, an instructor, and I see it, and I say, you're doing something you should not be doing, they're going to say, well, I'm getting paid, so I have to do it. I think that's the biggest issue in the real estate field right now.
Are there any particular areas of concern as to, we would need some examples.
Filling out listings for the brokers, sometimes signing for them, which is fraud. And so, you think, and also you are by law, right? You have 48 hours to rescind on a contract. So you go and get a listing, you fill it out, you have to mail it. Sometimes brokers, agents don't want to fill it all out here. Even agents will pay their assistants, here, do this for me, fill it out, or send it. Where it should be the broker and the salespeople individually, right there and then, send that copy to to the seller, to the buyer, whatever's signed. And I don't think that is fulfilled the right way. And that is why I took a little hiatus from all of it. And I decided I want to instruct, to show people the right way. I do think the way there's a CE credit course, 22 hours, I mean, it was revised, the grandfather law for the old brokers, for the new brokers and the new salespeople to always go for the CE credits. Absolutely. But I do believe the admins in an office should have legally with the Department of State what their procedures are. Because if there was that compared to what a broker would tell them to do, I don't know if it differentiates because I'm a broker and I'm paying as an employee. It should be, no, this is not what you do for a salesperson. No, this is not what you do for, there is that, I don't know, it's in between line where you have admins or office workers doing things they should not be doing. Now I like, oh, fill out the form, here's my listing, fill it out, send it out. Brokers, licensees should be always, with the license, with the state, should be informed and have copies of all their listings. Thank you.
Any comments or questions on that issue?
Mr. Vihil, I just wanted to mention there's a opinion letter that is many years old that addresses the issue of what non-licensee employees of a brokerage firm can and cannot do. But I believe the position of the department back then, and I'm talking at least 10 years old, if not older, but I believe the position of the department would be the same. I mean, the scope of what a licensee can do and what a licensee or a non-licensee can do has not changed. It's under an old administration, but I believe we would still stand behind it.
Can we see a copy of
Put it
that?
on our website. Yeah.
Yeah, we can dig it up.
I'll have Carol email it to everybody.
Yes. Besides emailing it, we'll update it. To the extent that it needs to be updated. With respect to references to law or cases, and make it available on the website.
That's fine.
Anyone else from the public? All right. So unless we have any other issues of concern for members of the board.
Mr.
Yes?
Hill, we have somebody in Albany. Have a comment.
Go ahead.
Thank you, Deputy Secretary, DOS staff, and directors. My name is Keith Oberg. I am the chairman of the Legislative Committee of the New York State Association of Home Inspectors and a licensed home inspector in New York State. And I'm here on behalf of an initiative by NYSAHI, New York State Association of Home Inspectors. Dave Clark, our president, intended to be here, but unfortunately had a change of plans and couldn't be. We have several initiatives before the DOS and have had for the last year. And one of them specifically involves realtors, and therefore this is a perfect venue to bring this issue up. So it is based a document that we have created that we would like to see home buyers be alerted to and have signed, probably in the process of signing a purchase agreement for a house. It's called For Your Protection, Get a Home Inspection. And this document is patterned after a similar document that HUD requires of a lender to give to a home buyer if it's a HUD-backed loan. Unfortunately, it's a great product they've created. Unfortunately, there's a very limited number of buyers who are going through HUD-backed loans, and therefore there's a large group that doesn't get this message. And I believe the message is important. There is several benefits to this document, one of which, of course, is obviously to potentially increase the number of home inspections in New York State. But in addition to that, it is important, it's basic consumer protection, that home buyers are aware of the value of a home inspection. And that's a number one point of this. Secondly, there has been a lot of confusion about the relationship or differences between a home inspection and an appraisal. This is particularly in the last few years as HUD has increased requirements on appraisers to do assessments of the condition of property when they do their appraisals. And that has engendered a lot of confusion. And I know that personally, and I'm sure a lot of agents have experienced that confusion also. Thirdly, I think that this document will go a very long way to reducing agent liability. Obviously, that's important to many folks here. To give you an example, there was a court case very recently in Western New York. Some of you are probably aware of it. There was an allegation that the foundation was not adequate in a home, and the buyer of that home alleges that the agents involved in the sale did not alert him adequately to the necessity of a home inspection, and therefore neglected to have one. The result of the case was that a 20% of the total judgment was laid against the agents involved, and I do believe that this document would have helped prevented that from occurring. The standard purchase agreement at this time does, most of them I believe, have a contingency page or separate addendums, contingencies for various services, including a home inspection, but there is no statement included about the value of that home inspection. And I think this would rectify that. Members of our organization have put this document before various local boards, including a member in my area, and got a very positive response from the agents at those meetings. And not only favorable, but some of the agents, including in our area, a couple of the larger agencies, indicated, well, yeah, they think this is a great idea. And in fact, they created their own documents for this purpose because there wasn't anything out there other than the HUD. So they kind of made their own. And that's great, but I think there's some issues with that. At the same time, some members of our own local board indicated that, yeah, they thought it was a great idea, and they would bring it up to their own board and perhaps have an initiative on a local level. But they were waiting to see if the state would do something in this regard. And I happen to think that that would be superior. If every local board does their own, or some do or some don't, first off, it's going to be very piecemeal. The definition of a home inspection may be somewhat in error. I think it would be better to have a document that is approved by our association as well as the Department of State and the legal representation to make sure that we really are saying what needs to be said in such a document. And I am also concerned that if it's a piecemeal affair across the state, that there will be even an increased liability for those agents who, for whatever reason, don't happen to participate in something like this. So I would urge this group to support this initiative on our part. And I think, again, that it is safe practice, as I heard the word term here earlier, to have this done, and I think it would be best done by the state on a statewide level. Take any questions if there are any.
Well, there are good home inspectors and bad home inspectors, like there are good realtors and bad realtors, I suppose. By requiring, if I understand the model, the real estate agent to provide this form, and if the inspector does a substandard job, is there a vicarious liability created here? Essentially, you're asking the agent to endorse the inspection process. In your words, I think saying it's good or it's whatever. So I just wonder if there isn't some liability transferred to the agent actually by providing the form.
That's a very good point, which might in fact come to play if the agents are taking it on as their own initiative, where if it's done on the state level, and in conjunction with the Department of State, I think that onus would go away.
Presently, we have a property disclosure form, which makes the seller of the home accountable. How I mean, that is a form that is state endorsed.
Well, if I may respond, first off, I don't think it really makes the seller of the home accountable because there is an opt-out that's often used, number one. And number two, it's clear on that form that it's only, the seller is only indicating to their knowledge the condition of the home, which is usually quite minimal.
So it also states on the form that this is not a replacement for a qualified home inspection.
Correct.
Right, exactly.
Okay.
And actually, that opt-out does not preclude the purchaser from later suing the owner. I mean, the opt-out does not preclude that. I mean,
Well, that's always a remedy, is a lawsuit, but I think it would be great if we could reduce the number of lawsuits in the state.
So is the purpose just to have a disclosure that a home inspection is important or necessary, or are you saying that it should be almost a requirement? Are you just saying it's a disclosure form that you're proposing?
Correct.
That you should
No,
get a
it is
home inspection?
Correct. It's a disclosure form that would be required to be signed by the purchaser of the home, indicating that they did receive that message. But again, it's not just the importance of the home inspection, it's also clarifying that distinction between a home inspection and appraisal, which has become an increasing problem. And it is also a protection for the real estate agent. Because again, that's not the only case, and I know many agents are concerned about this issue. They recognize the importance, but they're not sure the message is getting through, or at least it's being alleged that the message isn't getting through when a problem arises.
I mean, to the extent that we're also talking about the appraisals, obviously this is an issue for another board as well to consider. But from the Department of State's perspective, with respect to consumers, with respects to the position that the state is in with the effects of the recent storms across the state, there is an interest in alerting consumers about the importance of making sure that home inspections are done, that they're done properly, etc. So I think that there's a benefit to the consumer, and it's something that we would like to further continue to explore. Obviously, we understand we don't want to create additional liabilities upon the agents, and this is something that, to the extent that the board is interested, we should have a committee explore with the input of the Home Inspection Association. Besides NYSAHI, there are other organizations as well that should be brought to bear. Because obviously the language will need to be detailed. Hopefully it won't take us as long as the advertisement regulations, but it's something that I think that it's to the interest of all of us, particularly to reduce the amount of litigation that perhaps we can see in a few years if these home inspections are not done properly, or if no home inspections are done at all, and then there are defects found a couple of years down the road. So,
Mr. Beheel, I think that's a topic the Trends Committee could take a look at. All right, so I can add this to the agenda for our next Trends Committee phone conference.
Yes, unless there's any other suggestions from the board. Nope. All right. So let's add that to the next item. Any other public comments from Albany? Thank you. Any further comments in Albany? I don't see anyone in Buffalo, but just to make sure.
No, you're safe. Just the two of us. Thank you.
All right. If there are no further issues for the board, then we would move into adjournment. Can I have a motion on that?
Motion to adjourn. Second.
Second. Anyone opposed? All right. So the meeting is adjourned. Whitney, now we move it to the public hearing session. Would you like to address that item?
Sure. We are required by statute to have 3 public hearings a year. It's very similar to public comment. The largest difference is there's usually more back and forth between board members and the public during a public hearing as opposed to a public comment. We've always treated them similarly, but we are required to have 3 a year. So I'd like to call the public hearing to order. Is there anybody in New York City who would like to address the board? Albany? No one in Buffalo. Motion to adjourn the public hearing. Second?
have a second to adjourn?
Second.
In favor?
Aye.
All right. Public hearing adjourned. Thank you.
Thank you, everyone.
Thank you.